Good afternoon, and thank you for joining me for today's webinar about percentage entitlements in property settlement and family law matters. My name is Kathleen Daird. I'm a Senior Associate at Michael Lynch Family Lawyers. I've been practicing as a lawyer for over 30 years and in this jurisdiction for half of that time. Michael Lynch Lawyers is a specialist family law practice. We've been in existence for over 20 years and have 13 lawyers, 4 of which are accredited specialists. So together, we have many years of experience to help our clients with advice, negotiation, mediation, and court representation. This combined expertise is harnessed in our team approach, particularly in complex matters. Firstly, I'd just like to tell you about the many free resources that are available on our website, including our ebook, webinars and seminars, brochures, and if you're interested, you can also subscribe to our monthly newsletter and access our regular articles and publications. We provide an initial consult for a fixed fee cost, which is obligation free, and we strongly recommend that clients see us as soon as possible once they have separated, or even if they're thinking about separating, so that they can get some early advice about what might be best for them and what assistance we might be able to provide. So what is the scope of family law and our practice? We cover, I think, most things in family law, and that includes separation, divorce, property settlements, parenting arrangements for children, child support, spousal maintenance, domestic violence, relocation, change of name, paternity, and international child abduction. As family lawyers, we work closely with other professional experts to help clients navigate their post-separation arrangements. We may have to access records from family business accountants, have forensic accountants value businesses or trace assets, obtain advice from tax accountants about the impact the division of an asset might have for taxation purposes. This is particularly important for CGT events or changing the nature of a trust. We also encourage clients to obtain financial planning advice in determining the best way to manage or structure assets upon separation. We refer clients to wills and estates lawyers to obtain new wills, draft enduring powers of attorney, and arrange for their affairs post-separation. Clients often also need emotional support through this very difficult time, and we often refer people to psychologists and counsellors to provide assistance. So the questions we're going to examine in today's seminar are: what is property settlement? And how do we assess entitlements? What are financial contributions, non-financial contributions, homemaking and parenting contributions, and then future needs adjustments to work out the ultimate percentage split? The aim of this presentation is to give you an understanding of the considerations that are taken into account in determining property settlement. This is so to attune you to some of the possible benefits and issues your client may face, so that you may be able to provide some guidance and insight to your clients as their trusted advisor, without, of course, trying to give them legal advice yourself. Firstly, however, I just want to clarify a few terms that are often used in a generic way, which don't necessarily reflect the accurate legal position. People often say, "I'm going through a divorce," when in fact, what they're doing is negotiating a property settlement. Divorce is in fact quite separate legal action and involves the legal severance of a marriage. In Australia, since the introduction of the Family Law Act in 1975, we have a no-fault divorce system. It doesn't matter who ended the relationship or why the marriage ended. The requirement is that the marriage is broken down irretrievably, which can be proved by separation of 12 months or more at the time the application is filed. There is no obligation to make arrangements for children or property issues before the divorce is issued. Today, however, we're going to talk about property settlement. This is the alteration of people's existing entitlements to property. It is available to married couples and de facto couples who may meet the criteria. The aim of the Family Law Act is what is called the clean break principle. This means extinguishing the financial relationship between couples and ideally no joint ownership of assets, joint liabilities, to enable people to move on with their lives. When negotiating property settlement, each party has a duty of full and frank disclosure. This involves the exchange of financial documents. It is important always to keep in mind there is a time limit for applying to the court for property settlement. That is 12 months from the date of divorce if you're a married couple, and 2 years from the date of separation if you've been in a de facto relationship. There's nothing stopping parties, however, from trying to resolve their property matters prior to divorce on separation. And it may well be that the divorce happens sometime later. The next thing I want to do is dispel a few myths. Firstly, there's no presumption that the property will be divided equally on separation. It is not what you put in also, it's what you get out. It's not a mathematical calculation of your financial contributions, as other factors are taken into account, which we're going to describe later. Also, property division does not require a fire sale of the assets. Where possible, the sale of all the assets should be avoided, but may be necessary, for example, if the major asset is the family home and the other party can't refinance this. So what are the steps? There are essentially 4 steps, which are set out in the Family Law Act in determining property settlement. Prior to going through the process, however, the question must be asked, is it just and equitable to proceed with a property alteration? This principle is set out in the case of Stanford, which was a 2012 High Court case in Australia. In this case, parties were in their second marriage and separated as a consequence of one party having to live in a nursing home. One of the children, who was appointed decision maker, sought a property settlement so as to protect the assets of their parent from falling to the other party on death. The court found that a division of assets was unnecessary at this juncture because the party living in the nursing home was being cared for adequately, and as such would result, and a property settlement would as such result in the sale of the family home. So this is an important consideration to take into account prior to embarking on the 4-step process of property settlement, asking the question whether in fact there is a need for property settlement. Then we look at the 4 steps. The first step is to identify and value the net property. The second, to consider contributions of the parties. Third step is an examination of each party's future needs and whether one party is at a disadvantage compared with the other that would result in an adjustment being necessarily made for them. The 4th step is the overall division of property. Is it just and equitable? So we're going to look at each of those steps in turn. The first step is, what is the asset pool? This involves identifying all of the assets, liabilities, and superannuation of the parties. This means assets held solely, jointly, and severally, held by trusts or companies. And in the case of trusts and companies, this means whether held by one or both of the parties. When we talk about value, we mean current market value at the time of settlement. Current market value is not replacement value or insurance value. It is what the asset can be sold for. It may be necessary to obtain an independent expert report to determine what the value of the asset is, but the parties can't agree on value. So often we'll get a forensic accountant's report, for example, to value a business. The next step is to look at the contribution each party has made to the asset pool. So step 2 is to look at what contributions have been made. We look firstly at the initial contributions, for example, the money each party or the assets each party has brought in at the date of cohabitation. and if those assets were used as a springboard for the accumulation of further assets, for example, a deposit on a home. We then look at the contributions which were made during the relationship, and this includes financial contributions, which can include income, inheritances, personal injury payouts, gifts, loans, redundancy payments, lottery wins, and so forth. Non-financial contributions are those which are also very relevant and may contribute to the conservation of the maintenance, renovation to property, or management investments. The next thing we look at is the homemaking and parenting contributions. This might include the care provided by grandparents and the care of children from other relationships by one of the parties, for example, stepchildren. Post-separation contributions are then examined, and this can make a difference, particularly where there's been a delay in obtaining property settlement, often seen with the accumulation of significant superannuation post-separation. Then we do a retrospective analysis, considering each of the contributions one against the other. If one party has made a greater contribution, they will receive a percentage adjustment in their favour. This is a case-by-case assessment, assessing and weighing contributions against the asset pool. So what are the general principles when we look at contributions? Firstly, we have to understand that there is no presumption of equality. Also, when examining financial contributions, this is not a meticulous mathematical exercise, as this would give undue weight to direct financial contributions and overlook the indirect financial contributions, such as that of parenting and homemaking. Financial contributions are, however, more important in short relationships, and here an accounting exercise may well be more appropriate. In long marriages, financial and non-financial contributions are much more likely to be given an equal weight, where such resources are devoted to the benefit of a family unit. In long relationships, it is impossible and inappropriate to perform an accounting or financial analysis of the contributions. What is conducted is more of a weighing exercise, recognising that it may be impossible to evaluate the contributions of, say, a stay-at-home parent, recognising that without this contribution, the husband would not have been able, and I'm saying husband because that's the traditional situation, would not have been able to work the long hours and make the higher income. Then we look at what approach to adopt. Should we look at an asset-by-asset approach or look at a global approach of all of the asset pool? When examining contributions, we can adopt either approaches. The asset-by-asset approach examines what contributions have been made to each asset by the parties. This may be particularly relevant in second marriages, where a person brings into the relationship a significant superannuation asset or real property, for example. This asset may be dealt with in a separate pool where no contribution has been made to it by the other party, so effectively excluded from the property settlement. The global approach looks more broadly at contributions overall to the net asset pool. Either approach is acceptable. However, generally, the global approach is to be preferred. Examples of asset-by-asset approach being more appropriate are in short relationships, particularly where the finances have been kept separate. And this is often important where there have been significant post-separation contributions. These assets will need to be looked at separately to the pool that was accumulated up until the time of separation. The next thing we look at is the length of the relationship. Whilst there's no starting point of equality in long marriages, generally in such relationships, a finding of equality of contributions is most likely to result. This is because in long relationships, there are generally so many various contributions made over time, it is difficult to weigh them all up unless there have been contributions of great significance by one party. In short relationships, direct financial contributions to the property are of greater importance than other contributions, particularly where there are no children. So let's look at the initial contributions. If a party brings in a significant asset into the marriage, that will be very important, but the disparity of the initial contribution may be diminished over a long marriage when considering the other multifarious contributions made by the other party during the relationship. Some people talk about this, or judges I should say, talk about this as the erosion principle, as the initial large contribution by one party may be given less weight over time when considering the numerous other contributions made by the parties over a lengthy relationship. The question is, what weight is to be attached to this initial contribution relative to other contributions, and what use has been made of the assets? For example, was an initial contribution of $100,000 made by one party used as a deposit for the first home, which has then enabled the parties to increase their wealth over time? The question is, what weight must be given to the contribution in considering how it has been applied? Has the use of the asset been a springboard into greater wealth? Therefore, the question is not about the amount you brought into the relationship and that contribution being effectively quarantined, particularly in longer relationships. In short relationships, it may, however, be more relevant. So let's next look at direct and indirect financial contributions. Direct financial contributions relate to the acquisition of property. For example, paying the deposit to purchase a home. Direct financial contributions may also be applied towards the conservation and improvement of property, such as ordinary repairs, maintenance, and interest payments, which help conserve the property, such as a home. Significant renovations, which add value and thereby improve the property, may include such things as building a new bathroom or kitchen. Painting the home would also fall into this category. Indirect financial contributions to the acquisition, conservation, and improvement of property include where one party, for example, may pay for the living expenses, such as groceries or electricity, so that the other party can pay the mortgage. If one party pays the living expenses and the other party pays the mortgage, this is just as important as it has enabled that person to direct all their money towards payment of the mortgage and the accumulation of that asset. Next, we look at gifts and inheritances. Funds from an inheritance or a gift from a family member or a friend are treated as additional contributions the party has, or of that particular party who's received them. There is no rule that any money which was gifted is quarantined. Any money that was received, however, does not get refunded. That party will receive a percentage division in their favour in acknowledgement of the contribution which has been made. The court will need to consider various factors such as the size of the gift or inheritance, the timing of the gift or inheritance and when it was received, and how the gift or inheritance was used. For example, whether funds used towards the accumulation of assets or towards holidays or luxury items, which are not reflected in the asset pool. The inheritance will be weighed against all of the other contributions made by the parties. The receipt of an inheritance will be regarded by the court as a contribution by the party in receipt of the benefit. The next consideration are personal injury payouts or insurance payouts or such sorts of payouts. Personal injuries payouts can be difficult as an examination needs to be conducted as to what the payout was compensation for. Whilst damages received in a personal injury claim will be a contribution towards the property pool by the person in receipt of the award, it may also need to be balanced against the future needs that may have resulted from the injury. Whilst the award may have been used to pay out the mortgage, it generally needs to be considered also in the context for which it was paid, for example, loss of future earnings. In most cases, a damages award arising from a personal injury claim is a contribution made by the party who suffered the injury. However, it should not be considered in isolation because every contribution which each of the party makes to the relationship must be weighed and considered at the same time. For example, part of a compensation payout may be for receiving services provided from the spouse, which were in fact provided free of charge. The contribution assessment of an insurance payout for disability will depend on factors such as the decision to take out insurance, how the insurance premiums were funded, how the insurance payout was used, and other contributions made by the other party for the benefit of the party who received the disability payment, for example, care and support. The insurance payout may be more a windfall. In the case of Miller, the court held that the payment was not a windfall. It was a payment received by the husband because he suffered a heart attack. It matters not that this was a minor heart attack from which he recovered. Despite the husband's good fortune in this regard, his health into the future is significantly compromised as a result, according to the evidence of his cardiologist. Thus, although the fact that it was a joint decision to take out the insurance and the fact that the premiums were maintained out of the parties' joint funds, and whilst that can be treated as contribution by each of the parties, there is still a need, it's still needed to be a life-threatening event before that payment could be made. It is simply not open to the wife to argue that the parties have contributed equally to this payment. It is the husband's money, to which the wife has made an indirect contribution of a relatively minor nature. The next thing to look at are redundancy payments. So even if they're received after separation, they're often found to have been contributed by both parties, particularly in long relationships, because redundancy payment will relate to the length the person is employed for. This is because, for example, the husband's earnings are often possible because of the wife's homemaking contributions. So the husband will not have earned that income without the wife's support. This is a recent family law case looked at this matter where the couple had been together for 19 years. During the relationship, the wife had been the homemaker and parent to their 2 children, whilst the husband had worked full-time. The husband's redundancy payment was based on 2 times his salary, as well as a bonus to compensate him for the loss of future income. He submitted that the wife had made little, if any, contribution. Since the court had made findings that the parties had made an equal contribution throughout the relationship, the wife argued that it could not be said that she'd made no contribution to the redundancy payment. The court agreed with the wife, concluding that the wife had made a substantial contribution to the husband's earnings and the accumulation to superannuation during the marriage. The next thing to look at are windfalls and lotto wins. In most cases, such as a winning lotto ticket, such windfalls will be treated as a joint contribution in the same way that other purchases would be a joint contribution, unless the circumstances suggest otherwise. There are a number of cases where the court has had to look at when and who bought the ticket and what they thought they would do with the winnings. Other windfalls might include, for example, the increase in value of a property due to rezoning. This is generally considered a windfall, and therefore equal contributions of the parties would be an appropriate assessment where the increase in value is not due to any particular effort or act of either of the parties. Generally, it's assumed that a lotto ticket has been purchased from joint funds. In rezoning cases, which has improved the value of the property, generally this is considered as a windfall, and therefore equal contributions to the parties will be because of the result of the increase. The increase has not been due to any particular act of either of the parties. The next thing to consider are non-financial contributions. These are contributions where there's been no monetary reward. However, they will often add value, maintain and conserve or improve the asset. This will include such contributions as building a fence, painting, paving, gardening and landscaping, all those types of contributions are considered non-financial contributions. It may be possible, for example, to get an expert valuer in to determine what would be the value of the property if these renovations had not been done. Non-financial contributions can also include assistance from family members in caring for children with a marriage to allow one or both of the parties to engage in paid employment or education. This is increasingly common where two people are pursuing their careers. Significant assistance can often be provided by family members to care for children at no cost, which allows parties to pursue their careers and accumulate assets. Non-financial contributions may include those contributions such as managing money and entrepreneurial skills as an investor. Sometimes it might be that the wife's contribution has enabled the husband's creative pursuits, such as in the case of Whiteley, where Brett Whiteley's wife Wendy was his muse and the inspiration for many of his paintings. In the case of Zubik, the court considered that the wife conserved the husband's damages award by performing nursing duties free of charge. The next thing to look at is homemaking and parenting contributions. This is the recognition of domestic duties performed by a party during a marriage or de facto relationship. In considering the homemaker contributions, the court is not concerned with the quality or the performance of these duties, but the fact that they were performed and by whom. The domestic contributions of cooking, cleaning, washing, ironing are most often given equal weight to those of the breadwinner in recognition of the fact that without someone at home caring for the children, taking them to the extracurricular activities, to school and looking after the home, it would be very difficult for the husband to work, often long hours, so as to make the financial contributions to the marriage. The court also recognises that in most cases, the woman is the primary carer of the children, often sacrifices her career and superannuation to provide a nurturing environment for children, and as such, homemaking and parenting contributions are treated as equal in the circumstances. The court recognises that the comparison of the breadwinner and homemaking roles is different or difficult because the evaluation and comparison cannot be conducted on a level playing field. The comparison is between fundamentally different activities, one contributing to property and one contributing to the welfare of the family. Breadwinner contributions can be objectively assessed, unlike the homemaker contributions, which is to impose a value judgment as to what constitutes a competent homemaker and parent. It cannot fairly be equated to the value of assets, as there is a chance to undervalue the homemaker role. Early cases looked at the value of a paid housekeeper, and in the 1990s, the court said this was not an appropriate way to assess the role of homemaker and parent and what they add to the welfare of the family. The Family Law Act does not indicate the relevant weight that should be given to different contributions. So the court must, and in each case, have regard to the matter which the Act requires it to consider and do what is just and equitable in the circumstances. The contribution of a party as homemaker and parent must be assessed not in a token way, but in a substantial way. In the case of Lambert and Lambert, an English Court of Appeal case, here the court really summed up the position of the court in dismissing the assessment of whether you are an excellent homemaker or an average homemaker and the value judgments inherent in that. The court said, the danger of gender discrimination resulting from the finding of special financial contributions was plain. If all that is regarded as the scale of the breadwinner's success, then discrimination is almost bound to follow, since there is no equal opportunity for the homemaker to demonstrate the scale of her comparable success. Examples previously cited of the mother who cares for a handicapped child seem to me radical and distasteful. Such sacrifices and achievements are the product of love and commitment and are not to be counted in cash. The more driven the breadwinner, the less available he has to be physically and emotionally, both as a husband and a father. The next thing to consider are special skills and the contributions that they make. The special skills doctrine relates to the special or extraordinary contribution which should result in extra weight given to that contribution, particularly if it results in the creation of large wealth. This is rarely relevant, but it may occur where, due to the business acumen of one of the parties, they have accumulated massive wealth. It occurs where people have really done something which has created such a large asset pool it needs to be given special weight. There is, however, controversy in case law as to when this doctrine should apply. In the case of Mallet, special skills were discussed, and in that case the court found that a conclusion in favour of the quality of contribution will be more readily reached where property in issue is the matrimonial home, superannuation benefits, or pension entitlements, if the marriage is of long standing. It will be otherwise when the property isn't, but it consists of assets or acquired by one party whose ability and energy has enabled the establishment of an extensive business enterprise to which the other party has made no financial contribution, and where the other party's role does not extend beyond that of homemaker and parent. In contrast to the doctrine of special skills is the doctrine of marriage partnership. This is where marriage is regarded as a genuine partnership in which each party brings different gifts. The fact that one party is productive of money and in large quantities is no reason to disadvantage the other, as was found in the case of Higgins. The law in this case came to a head in the case of Fields and Smith, 2012 case. In this case, the parties had a very long marriage of 29 years and were separated for a further 4 years until trial, and then a further 5.5 years until the appeal was determined. The husband and wife were aged in their 50s, and the parties produced 3 children, all of whom were adults at the time of the trial. It was agreed that neither party had made significant initial contributions. The parties established a construction business on the Gold Coast, of which the husband was the driving force. The wife was also directly involved in the business, to some extent as a director and shareholder. The parties sold 16% of the business to 4 employees in 2006 and built their extravagant home, which was completed in 2008 at the agreed value of $10 million at trial. The total asset pool of the parties at trial was between $32.3 and $39.8 million. At trial, the judge rejected the doctrine of special skills and marriage partnership, made a 60-40 assessment of contributions in favour of the husband because of his ingenuity and stewardship with respect to the business. The crux of the argument on appeal was an assertion by the husband that his contribution should be seen as special or unique or out of the ordinary. The wife asserted that the wealth of the parties, whatever type and however described, was as a result of an economic, domestic and emotional partnership, and as such, that this is an unjust or inequitable to distinguish between their contributions. The special contribution in this case was the creation of a very successful business, which started in 1990, developed to having a significant value between $32 to $39 million at the time of trial in 2012. The full court found the words in Section 79 do not provide endorsement of the category of contribution related to any class of property, for example, high worth, being by virtue of that category or class more valuable or important. In each case, the contributions made by the parties must be evaluated in the context of the facts of each case. The full court upheld the 60-40 split because of the particular housing design the husband had created, which resulted in the exceptional wealth of the parties. This case is really saying that there is not some monetary threshold where you can suddenly fall into a category where extra credit is given for the accumulation of wealth. This position is also reiterated in the case of Greer and Malthus, where the court found it is not a party's skill set which must be considered, but their contributions. Contributions are a product of many things: talent, industry, selflessness, I should say, and indeed luck, to name a few. It is the contributions in all senses in which that expression is issued or is used in section 79, which fall for consideration and assessment, not the combination of factors that has created the capacity for making those contributions. So now what we really need to look at are whether there are special skills and how they should be examined. And this obviously is still a very controversial approach when assessing contributions each party has made. The next thing to consider are post-separation contributions. Post-separation contributions to a relationship do not stop being relevant once a couple separate, and they may be significant because of the delay in obtaining property settlement. This may include a substantial increase in the superannuation, for example, from the date of separation to the date of property settlement. Post-separation contributions refer to those contributions made by a party to the relationship from the date of separation until the matter is finalised. If property was purchased by one party after the separation, it would be considered part of the property pool in the split, unless the property was obtained using funds that were not part of the asset pool. If the property was purchased because of an inheritance one party receives after separation, it could be considered as merely as a resource. If purchased from joint funds, however, it would form part of the pool. Post-separation contributions can become more complicated when there are delays in proceedings, and this has been particularly seen where one party has won the lottery or received a gift or inheritance post-separation. It may be useful to use an asset-by-asset approach, where the period between separation and trial is substantial. There are cases where these post-separation contributions have been considered. In the case of inheritances, Colvin and McTeer, lottery wins, Farmer and Bramley, and assets accumulated post-separation from employment in the case of Trask and Westlake have all been included in the asset pool. And the other party has been entitled to a share due to the homemaking and parenting contributions made during the relationship and post-separation. In the case of Calvin and McTeer, one party obtained an inheritance of over $8 million, to which the other party was entitled to some, as was the case in Farmer and Bramley, where there was a lotto win. The next thing to look at is post-separation homemaking and parenting contributions. Post-separation contributions can be both financial and non-financial in nature and do not stop being relevant once a party separates. Post-separation contributions of a homemaker and parent, as compared to those of a primary income earner, are often equated in those circumstances. In the case of Trevi and Trevi, the court found not only must contributions of all types be considered over the whole of the time up until trial, but also the post-separation period can see contributions of a type made during the marriage become more onerous. For example, homemaker and parent contributions made within a household comprising the marriage partners and children, which are made by only one party after separation, may be more extensive. The next thing to look at is bad behaviour, which is sometimes referred to as negative contributions. And often people raise the issue of infidelity or moral wrongs here. Unfortunately, they're generally not relevant to the assessment of contributions, but can certainly be relevant to the dynamic of negotiations. Losses incurred by either party or both of the parties during the marriage, for example, bad investment decisions, should generally be shared, although not necessarily equally, unless one of the parties embarked upon a course of conduct designed to reduce or minimise the pool of assets, or one of the parties had acted recklessly, negligently, or wantonly with the matrimonial assets, and the overall effect has to be to reduce or minimise their values. Wasteful behaviour can also be relevant, for example, where significant funds were wasted on gambling or alcohol or drugs. This can be considered a negative contribution. So some examples of waste are found in the case of Nikos and Anthos. Here, the husband's gambling amounted to between $200,000 and $400,000, and the court found this to be in no way proportionate to the party's lifestyle or his contributions during the course of the relationship. The gambling was an aspect of the party's contributions which led to a finding that the husband's contributions to the non-inherited assets was only 10%. The deterioration of a house while the husband had sole occupation of it was considered in the case of Karen and Leniga. Here, the full court upheld the trial judge's findings that the husband had wasted part of the value of the home. The home was previously valued at $525,000. At the time of trial, another expert found the house to be between $270,000 and $300,000, but gave the opinion that it would be worth in the mid-$500,000 range if it was of an average condition. The husband had cash of about $150,000 at the time and therefore had financial capacity to fund repairs, whereas the wife had only meagre resources. The husband had sought to retain the house, but did not rationally explain why he had not repaired it. The dilapidation of the house was not seemingly caused by mere inattention to regular maintenance. The husband told the experts the property was structurally unsound and access to the house was only by way of a stepladder propped against the side of the house. What about domestic violence? This is often seen in family law matters and can be taken into account when considering property settlement. It can be considered where it impacts on the victim's capacity to contribute. Where there is a course of violent conduct by one party towards the other during the marriage, which is demonstrated to have had a significant adverse impact upon that party's capacity to contribute to the marriage, or put another way, to have made his or her contributions significantly more arduous than they ought to have been, then that is a fact which a trial judge is entitled to take into account in assessing the parties' respective contributions. And those principles are set out in the case of Kennan, which is the 1997 case. The next is to consider future needs. This is an examination of the needs of each party going forward from the relationship. The most important factors include the comparative ages and health of the parties, their respective income and earning capacity, the care of the children, the duration of the marriage and the effect on the party's earning capacity, who's going to be retaining the assets which might have a contingent CGT liability, the future prospective inheritances that the parties are likely to receive, the disparity in the asset position of each of the parties, for example, an inheritance that has been excluded from the asset pool. And if one party has greater future needs, they may receive a percentage adjustment in their favour. So what are the general principles here? The court must take into account all relevant factors and the weight to be attached to each factor, and that's a matter for the court's discretion. This includes the relationship between property settlement and spousal maintenance. For example, property settlement is considered first and must be considered in determining maintenance. So, for example, where there's been a very significant property settlement, it may be the case that even though one party is left without the capacity to earn, they're given such a substantial property settlement that effectively compensates. And that's because the future needs factor is seriously taken into account when determining property settlement. The assessment of future needs is not a process of social engineering. This means that the court can't fully compensate for the fact that one party may have a significantly larger earning capacity than the other party. One party is unskilled. Unfortunately, their income is likely to be much lower than somebody who is highly skilled and is going to be earning a significant income for the remainder of their life. The court can't attempt to try to put them in an equal position. The future needs adjustment must be looked at in monetary terms rather than just strictly percentage terms. This means, what is the actual outcome of the property settlement in real terms? Clearly, in larger estates, small percentage adjustments may amount to hundreds of thousands of dollars, where the opposite is the case in small monetary matters. So people may argue over a 2 or 3% percentage adjustment in very large matters, because that might amount to hundreds of thousands of dollars, where that's not the case in smaller matters, smaller money matters. The next thing is to look at earning capacity. In property proceedings, it is open to a court to give weight to the ability of the party to earn income, especially where the opportunity clearly exists to utilise that ability, whether or not it's appropriate to require a party to work particular hours or work a particular occupation is a question peculiarly within the province of a trial judge and needs to be measured on a case-by-case basis. So, for example, if you've got a party who has decided not to work, even though he has professional skills and he's been working right up to the date of separation, the court will take into account that person's earning capacity and skills. The care of the children is also a very important factor when looking at future needs. The payment of child support in no way compensates the custodial parent for the loss of a career opportunity, the lack of employment, mobility, and the restriction of an independent lifestyle, which the obligation to care for children usually entails. It is recognised that the sole care of children will also impact on the capacity to repartner and thereby rebuild wealth as a couple. Life expectancy is also an important factor. One party has malignant melanoma and a year to live, and that's going to obviously be relevant to their future needs. The next thing to look at is justice and equity. So after we've gone through all of those processes of assessing the contributions, the court must end the analysis by determining what is the appropriate order and ensure the practical effect is just and equitable. So the court looks at the percentage division of the property pool and the overall outcome, adding together step 2 and step 3. Is the overall effect just and equitable? So when looking at the practical effect of the orders, you look at the specific asset pool, not just the percentages. It's the mix of superannuation and non-superannuation. Is one party getting all of the super and the other party getting the assets? And is that just and equitable, particularly if the parties are looking towards retirement shortly? The court also looks at the clean break principle and tries to, as far as practicable, make such orders that will finally determine the financial relationship between the parties of the marriage so as to avoid future proceedings between them. This is to extinguish their financial relationship as far as practicable, so as to avoid ongoing joint ownership of assets. Well, look, this brings today's webinar to a conclusion. I'd just like to thank you all for attending today's webinar on percentage entitlements and property settlements in family law matters. If you'd like to know more or have some specific topics relating to family law that you'd like some answers to, we can come to your firm and give a more in-depth presentation. You can just email us at law@mlynch.com.au. I also encourage you to complete the feedback survey, which will be sent at the end of this seminar. And I'd like to also invite you to have a look at our past webinars, which are on our website. Thank you.